That day, you may remember that we started with the banker-customer relationship, where I defined the term banker first and then went on to define the term customer. Then we recognized, we understood as to how the banker-customer relationship is seen in law. Uh, Basically, we recognize that it is a contractual relationship similar to the relationship between the debtor and the creditor, where we identified the banker's role is that of a debtor and the customer's role is that of a creditor, where the customer is a creditor and the bank is the debtor. That is the bank creditor debtor relationship that we identified between the bank and the customer. Then we uh, went on to discuss duties of a customer towards the bank, where we identified that in terms of the common law principles, there are two main duties that a customer owes to his bank. Those are Macmillan's duty and Greenwood's duty. That is basically to draw checks in such a way using reasonable care so that the bank is not misled and frauds are not facilitated. That is Macmillan's duty. When it comes to Greenwood duty, what it means is that if there is a fraud happening pertaining to the bank account of a customer is duty bound to inform the bank forthwith, immediately. Those are the two duties. Then we went into certain other cases like Tai Hing Cotton Mills versus Liu Chongqing Bank, where I explained that has been instances, there have been instances where customers have successfully argued that a customer does not have anything more than those two duties uh, towards the bank. You may remember that case where I said that bank argued that it's the duty of the customer to read the bank statements and understand what was there and to complain if there has been any fraud or something like that. But customer successfully argued and the court accepted that the customer does not have a duty to read bank statements. And again, I stress that all these things are common law principles which can be varied by certain contractual arrangements. You can then get the customer to agree that he will read the statements sent by the banker. So, the present day challenge of a banker is to look at the customary and traditional principles of banking law and to bridge the gap between those principles and the modern day requirements. When it comes to practical banking, you will see that some of these concepts may not work in the same way. So you need to understand that and somehow bridge that gap. In any event, now I'm today going on to the duties of a banker towards the customer, the other side of the relationship. As much as the customer has duties towards the banker, bank also has duties towards the customer. What are the banker's duties towards the customer? This is to honor the customer's checks. Banker has a duty to honor the checks drawn by the customer. But this duty is conditional upon few things, which are the checks need to be properly drawn. If the check is not properly drawn, bank is not duty bound to honor that check. And the customer should have a balance to his credit, that there should be a positive balance. Exception is that if the customer has an approved OD facility, then customer may draw even beyond the limit of money available in his account and even in instances where money is not really available. But other than that, the customer has a duty, the banker has a duty to honor the checks written by the customer only if customer has a credit balance, the positive balance in his account. The other thing is that bank is not duty bound to pay if there is any legal bar or restriction attached to the customer's funds in his account. I have given an example, which is a Garnish Order. Before going into Garnish Order, I would simply tell you that you all know those who are in banking sector, banking and financial sector, and lawyers. We all know that there are a lot of orders issued by courts, most instances initiated by the central bank, where the customers' accounts are sometimes frozen. You can't make a payment out of the account. Uh, to take some examples from recent issues, just take the case of certain unlawful finance businesses who have been taking deposits from general public. We have got court orders restricting the operations of basically freezing the accounts of those who have carried out such transactions. In the sense, those who have run those schemes, those who have accepted deposits. Now they can't move their money out of their accounts. There are certain directors of certain companies which are supposed to have engaged in unlawful activities and fraudulent activities. Their accounts have been frozen. They can't take money out of their accounts for quite some time. There are certain institutions, the directors of certain institutions, whose accounts are blocked for last more than 12 years. The reason being, there is a kind of a alleged fraud or unlawful activity. In those circumstances, we might get a court order to block the accounts. Even without a court order, central bank in certain instances request the bank to freeze the accounts of particular parties, and those need to be followed up with court orders taken during a particular period of time. Uh, for example, in case of those engage in unlawful finance businesses, what we do as a first step is that we block the accounts of those perpetrators uh, by sending an order to the relevant bank, all the banking institutions. After that, we go to courts and get a court order. Now, the general principle is that when there is court order, uh, legal restriction, you should not pay. That equally applies to any other legal order, like that of those issued by the central bank under a particular law. If that is lawful, then the banker is not in a position to pay customers checks, or banker would not allow that kind of a customer to withdraw his fund withdraw from his account. Now that is generally accepted that when there is a legal bar, you cannot uh, withdraw money. You cannot draw checks on your account, right? Those will not be honored by the bank. But the issue we are discussing here is that generally the bank is bound to pay checks drawn by the customers. That is a duty, but there are exceptions. If the check is not properly drawn, if the instructions are not clear, bank is not bound to pay. If the customer doesn't have enough money in his account, the bank is not bound to pay. Uh, if there is a court order or some other valid order issued by an authority, the bank is not bound to pay. The last point I have mentioned as an example, a garnish order described in this slide. What it means is that court might give an order. It works like this: there is a particular debtor who has obtained money from a particular creditor. Debtor keeps on absconding and doesn't pay. Then the creditor can go to the courts and get a uh, order against the debtor. That is possible. In addition, if the creditor can point out to some person who holds money on behalf of the debtor, court can issue an order to the person who is holding money on behalf of the debtor to repay to the creditor, right? The same principle applies if someone can points out that, look here, my debtor is absconding, he doesn't pay me, he has defaulted the repayment to me, but he has money in an account in the bank. So courts are in a position to issue an order to the bank requiring, ordering the bank to pay to the creditor. In those circumstances, even if the customer comes to the bank and wants to obtain money by way of a check or something, bank is not bound to pay because there is a valid court order. This is only an example. Uh, Bank is also bound to abide by the standing orders of the customer given for various reasons. It may be for a periodic payment such as insurance premium, or else certain other things, loan settlements or whatever. Sometimes maybe settlement of utility bills, settlement of a credit card. All these things can be done by way of standing orders issued by a customer. Generally, in the traditional law, what is supposed to be, what the main instrument of what I was telling you was that standing orders are supposed to be honored by bankers. That is a that is also a duty of the banker towards the customer. Uh, Now I'm on the next slide. I hope you can see banker's duty of secrecy. Banker's duty of secrecy is one other duty of the banker towards the customer. This is little complex and much more relevant, or else, I mean, other two, first two things that I mentioned are ordinary contractual relationships that anyone would see. But this one is little different, but it's very important. What it means is that bankers are supposed to observe strict secrecy, confidentiality about the customer's account. Uh, that duty of secrecy arises even at the moment of opening an account, and it continues throughout. And it continues beyond the time point where the account is closed. Even though the customer ceases to be a customer of the bank, meaning that he closes the account, the duty of secrecy on the part of the banker continues. One may argue that it continues even after the customer's death. That is the very ambitious kind of the expectation from the banker, that banker should protect the secrecy of the confidentiality of the information pertaining to the customer. Even if customer has a positive balance or negative balance, no matter whatever it is, the bank is duty bound to protect the confidentiality, secrecy of the customer. Now, this has a kind of a considerable history, especially stemming from this case, landmark case called Turnier versus National Provincial Bank, where the facts are like this. The customer of this defendant bank, that is Turnier, plaintiff, uh, basically the plaintiff had an account with the customer, the defendant bank, and his account was overdrawn at a particular point of time. And he signed a kind of a agreement with the bank to pay off the overdrawn amount in weekly installments. He had an overdrawn amount, and he agreed to settle that in weekly installments. Uh, on this document, on his agreement, he wrote the name and address of his employee, his employer, not employee. Uh, he was working with some person, some place. He wrote the name of that place, that person, uh, and gave it to the banker. But this man could not make those weekly payments as agreed. Then the bank manager thought of recovering the money due from this customer, Turnier, and he thought that if he's not going to pay, why can't I call his employer? Because employer's name is there, and we'll ask the employer, tell the employer about this man. So bank manager informed that this particular person has defaulted the bank and this is his problem, and he is kind of a default, and all these things are informed to the employer. And employer didn't want to extend this man's employment contract, having heard that this has he has for defaulted banks and so on, having heard his bad credit history. Employer didn't want to keep him in his employment. So Turnier lost his job. So Turnier sued the bank for slander, that is, kind of defamation, and for breach of implied contract that the bank would not disclose confidential information pertaining to his account. This fact that he has an overdrawn balance and fact that he has agreed to pay that in weekly installments is an agreement. It's clearly it's the understanding between the bank and the customer, and bank is generally bound to protect such information. Now, argument plaintiff argued that bank has basically informed his employer about his credit history and the fact that he could make the payment as agreed. Even the rearranged thing he could not be honored. Um, and the fact that bank having traced payments passing from the plaintiff to a bookmaker, kind of gaming and betting place. There are payments going to a particular place where gaming and betting is taking place. So bank gave the insinuation or kind of indication to the employer that this man must be into some kind of addiction, some gaming. That may be why he is having financial difficulties. Uh, then later it was found that this particular payment to a bookmaker was not in fact by way of bets or something like that, but it was a payment for a supply of goods. Uh, in any event, now this is the position before the courts. The court decided that the bank was guilty of the breach of secrecy. The duty of secrecy is a legal duty arising out of the contract and not merely a moral one. One might think that duty of secrecy is a moral duty, that the customer has divulged a lot of information about his personal accounts and credit and things like that. To protect the secrecy of that information apparently is a moral duty. If someone gets that information, it's not up to that person to tell it to everyone that this person has this much of money and he has this kind of debts and things like that. That's moral, that's correct, but it's not only a moral duty, it's a contractual duty. When it comes to bank customer relationship, it's a commercial relationship, it's contractual. A necessary part emanating from the contractual obligation is that the confidentiality has to be safeguarded by the bank at all times. If that is not done, the bank is in breach of duty. The court was of the view that the obligation of the banker extends to all information and transactions that go through the account, including securities, guarantees, if there are any, and it extends to information obtained from sources other than the customer's account, whichever the source is. A bank is bound not to divulge information to any third party. Uh, and this duty is applicable even in respect of information of the bank has obtained prior to the start of the uh, bank customer relationship. Probably in the today's present day's context, in certain relationships, always they are supposed to do KYC, CDD, but there are certain instances where CDD and KYC might done before the transaction is entered into. Even in that situation, you see that information comes into the hands of the bank before the real bank customer relationship. Even in those circumstances, the bank is bound to protect secrecy pertaining to that information as well. Now, it's a kind of a serious duty. Still, it's not an absolute duty. Can you see that slide? This is not an absolute duty, meaning that this is not it's not an abstract duty. In the sense, there are exceptions to the Turnier's case, the rule established in the Turnier's case. What are those exceptions? Bank might disclose information pertaining to the customer where the disclosure is under compulsion of law. If the law compels the bank to disclose information, certainly bank can give information. I'm not going to describe these four elements of exceptions because I'll go into details with regard to the present context, that is the Banking Act. And where there is a duty to the public to disclose. That is what the case mentioned. If the bank has a duty to the public to disclose some information, he would disclose. Where the interest of the bank requires such a disclosure, probably there are circumstances where the bank has to disclose certain information in its own interest. That kind of a situation is also covered in Turnier's case as a permissible point where information can be divulged. And the last point is where the disclosure is made by express or implied consent of the customer. If the customer has expressly or impliedly consented, then the bank can divulge information to another party. That is what the exceptions say. Now, when I go through these four exceptions, sometimes certain things are not very clear. This was a judgment given in 1924. And probably in today's context, these things may not apply in the same sense equally, but almost all the countries have enacted their respective laws to address banking secrecy in a suitable manner. We look at how Sri Lanka handles that uh, when it enacts Banking Act number 30 of 1988. In section 77 of the Act, there is a provision like this. Every director, manager, officer, or other person employed in the business of any licensed commercial bank or licensed specialized bank shall observe strict secrecy. They are supposed to observe strict secrecy. Who are supposed to observe that? Every director, manager, officer, other person. Anyone in the banking institution is supposed to observe strict secrecy in relation to all transactions of the bank, its customers, and state of the accounts of any person, and all matters uh, relating thereto. All these things are supposed to be covered by banks. They cannot divulge information pertaining to transactions, customers, and so on. You see that here the focus is not on customer information, but customer information is also protected. Basically, this covers all transactions of the bank and its customers. That is where it is relevant to our topic, bank customer relationship and state of accounts of any person. That again uh, is connected to our topic. So, bank is bound to protect secrecy in Sri Lanka in all these circumstances. In Sri Lanka, again, there are exceptions like these. Right? Section 77 recognizes exception that when required to do so, meaning when required to divulge information by a court of law or by the person to whom such matter relates. If a court of law requires information to be given to a customer, to somebody, despite the fact that customer bank customer relationship is there, Section 77 of the Banking Act is there, banker can give information to such a third party because there is a valid court order. That court order would enable the banker to go against the banker's secrecy towards the customer information and divulge information to a third party. And if there is when required to do so by the person to whom such matter relates, the owner of information, basically the account holder, can ask the bank to divulge his information, meaning that the account holder has consented, customer has consented, customer has consented or requested to give information to a third party. You know that very often customers request the bank to give information of their accounts and status of accounts to certain third parties. I'll take a very common example. If say say you want to obtain visa to a particular country, you need to divulge your status of your accounts, how many, what are the deposits that you have, and what are your financial assets. Those will be divulged by the bank. You will see that every bank would put up a, I mean, kind of a statement in that kind of a disclosure to say that this information is released at the request of Mr. So and so, the customer's name. So, at the request of the customer, information can be given. Probably in commercial transactions, certain in when people enter into certain contracts with others, contracting parties want to know the other party's financial strength. They want some sort of an independent verification. In those circumstances, that the other party can authorize their bankers, can request their bankers to issue a confirmation as to what their financial strength is. Now, those circumstances are basically instances where customer consents, customer gives permission, customer requires the bank to divulge information. In those circumstances, bank is not prevented by bankers' duty of secrecy. The word, the terminology used in the act is that by the person to whom such matter relates. By the person to whom such matter relates. එම කාරණය අදාළ වන තැනැත්තා විසින් ඉල්ලා සිටි විට දෙන්න පුළුවන්. Now, you would see that this bank secrecy is a very kind of a controversial area. Very often, different parties, third parties want request information. For example, my personal experience is that almost every week I get some sort of a court order from some court somewhere in Sri Lanka saying that accounts of these people, account details of these people are required for a criminal investigation. Court has ordered you to provide information. Uh, for your information, I have never given any information of any customer to that kind of a court order. And normally, I very courteously write to them, telling them that these are the circumstances in which I can't give this, collect this information and give it to you. If you need, you can issue it to the particular bank and get information. And as a courtesy, sometimes I send a list of banks as well. You can get it from them. Then, in most cases, the problem is that the court or the police is not aware of any bank account of any person of the person suspect. So what they want is to have a kind of a general search in all banks. That is something not possible. What to do? There are certain smart police officers as well. One day I refused to give information to a particular police division, telling them that we are not in a position to do that legally. And he asked me whether he can ask a the particular bank to divulge information. I said, no, bankers are duty bound to protect secrecy. Even if you ask them, they will not give you information. Then he said, no, uh, I'll write to them with a copy to you, meaning to me. And after 2-3 days, he has written to the particular bank with a copy to me, saying that he is making this request under provisions of Section 77 of the Banking Act. He is in charge of an investigation into the account of a particular person. Therefore, I am a person to whom such matter relates, and bank is bound to give me the information. Now, that is his argument. Uh, Probably the bank would have also considered that. Uh, then I immediately intervened and told the bank and that person, no, this your interpretation is wrong. This is a reference to the account holder, customer, and not to a police officer. So you need to be very careful in divulging information. I'll tell you what the repercussions would be if you divulge information. Sometimes, in banking, you might sometimes come across situations where very innocent actions on the part of the customer bank officers might result in uh, violation of Section 77. You may be aware of a particular incident happened, I think, in 2017 also, of a particular bank. I think some 400 or 4,000 customer names were sent to a wrong mail list, right? Uh, Recently also there was an incident which is of less magnitude, but in some sort of equal circumstances. Unnecessary details have been divulged to parties. Now, how do we argue in those cases? Are they really violations of Section 77 or some sort of a mishap where someone has wrongfully given information? Yeah, you can say that you didn't do that intentionally, but it was a mistake. But there can be repercussions coming from certain strict liability provisions as well. And you see, on the other hand, now this NMRA incident, even if it is an incident, the mistake, even if it is a mistake, there are a lot of repercussions when confidential information is unnecessarily divulged or uh, deleted or something like that. Uh, I remember a particular bank, a senior officer of a bank, told me about 2 3 years back as to how a particular employee of that bank has run into a serious problem. There has been a particular customer of that bank, and that customer has opened an account for and maintained account for a long period of time. She had the building and she rented out space of that building to different parties, and one of those parties are supposed to deposit their monthly rental into the account of the building owner, which was maintained at this particular bank. Now, after 2 years or so, this landlord, the owner of the building, was not very happy with one of the lessees, and asked that person to vacate the premises on the ground that the lessee doesn't pay the monthly lease amount, the amount uh, regularly. Then the lessee argued, no, I have paid everything into your bank account. Then the building owner, the customer of the bank, said, no, you have not paid. I don't have your, according to my records, you have not paid. If you have proof, you can show me. Because this lady was sure that this person may not maintain records properly. Then the other person looked into her records and found that during the last 24 months, she has regularly paid the lease rental on the relevant day, and she had 22 paying in slips, copies of the slips. uh, so she didn't have two copies. I think she has made electronic transfers of something, like for that reason she did not have paying slips for 2 months. She had 22 with her. So with these 22 she went to a bank branch and showed it to a person in the counter and said that these are my monthly installments for last 24 years. There are 22 slips. Can you please help me to uh, find out whether I have made some similar payments in these two particular months. Those are the 2 months in respect of which slips are not there. Then this very innocent, kind-hearted person helped the person at the counter to find out when similar payments have gone into that account. And this person turned back to the landlord, who is the account holder of this bank, and said, look here, you are lying. I have 22 slips and I checked with the bank. Also, bank confirmed that in other 2 months also, money has gone into your bank account. Then bank's customer, that is the landlord, the owner of the building, turn back to the bank and said, you have done something wrong. You have divulged my information to someone else. This is unlawful, wrongful. And this argument went on, and the poor employee was taken to task for divulging customer information. Right. Uh, you see, it's very serious. Even in a very kind gesture, kind action might result in unnecessary liability. And in fact, this senior officer of the bank wanted some sort of a defense for this officer, like how to come out of this incident. Then I formulated a particular defense and gave, and apparently later on I was told that that defense was successful and she was basically exonerated with a mild warning that this thing should not happen again. Right? We don't have to worry about the exception found there. Anyway, we have two other the exceptions to the rule. In the performance of the duties of the director, manager, officer, or other person, if you are diverging information in the performance of the duties of the director, manager, officer, or other person, then you are protected. These duties may come in from certain regulatory requirements, contractual arrangements, and so on. Those are generally covered in Section 77. And also, in order to comply with any of the provisions of this Act or any other written law, there are a lot of legal statutes under which customer information are supposed to be divulged. Probably I may have given here certain things. Yes, these are things, evidence ordinance, bribery act. This inland revenue law is now repealed. Anyway, that one. I don't know what, there's a mistake. This inland revenue law, that reference is wrong. After this, 2006 Act came, 2017, number 24 of 2017 is there. Uh, I don't think that we had 38 of 2000. It was 28 of 1979 and then something of 2000. I can't remember what it was. Anyway, don't this you can easily forget about this inland revenue thing because we have much more important things now, especially the last point. The Financial Transactions Reporting Act number 6 of 2006, which is FTRA. Under FTRA, you are supposed to give certain information pertinent to the customers to FIU, Financial Intelligence Unit of the Central Bank. What kind of information? You will see that under Section 6 and 7 of FTRA, there are two particular types of reports you are supposed to file. One is cash transaction reports, CTR, and the other one is suspicious transaction reports, STR. Whenever a customer engages into enters into a transaction, it may be a deposit or maybe a withdrawal of more than 1 million rupees. Uh, that has to be reported to the central bank. That is a cash transaction report. Now, in reporting so, you are not violating the requirements of Section 77 because there is a requirement by a law. You are honoring that requirement, so you are not doing something wrong. And also, there is this suspicious transaction reporting thing under Section 7 of FTRA. According to that, if the bank is of the view that a particular transaction is suspicious for the reasons that uh, something like peculiarity of the transaction and nature of the customer and things like that, the bank is supposed to, financial institution is supposed to report that to the central bank. Irrespective of the amount, generally cash transactions reporting arises where the amount is more than 1 million. But suspicious transactions reports can be generated even when amount is less than that. So you'll see that that is based on suspicion. So bankers are sometimes supposed to suspect the customer and inform that to the central bank. In those circumstances, you are protected, right? That protection is given there. Uh, that is the position. Now, What is the now? No, you will see that last week what I did was very often I took the concept in English law, English common law, which forms Sri Lanka's common law also, and compared that with certain statute provisions and modern law provisions. Now, here, banker's secrecy. What do you think? There is secrecy provision in the English common law emanating from Turney versus Turnier's case, and the statute provision that is in Section 77 of the Banking Act. How do you think that these two things operate in day-to-day life? What is the interoperability or operability of these two things? How do they work? Uh, will Turnier's principles apply in Sri Lanka, or will the provisions of uh, the Banking Act apply? Some people say Turnier's Act is general common law that has been replaced by the provisions of the Banking Act, and therefore only the provisions of Banking Act should apply. But my take is totally different because of the reason that Turnier's case casts a duty upon the banker not to divulge information. But what if information is diverged despite principles enunciated in Turnier's case? The resultant position would be the banker is supposed to be guilty of breach of contract and banker is supposed to pay damages. That's it. Banker will pay damages. That's it. But under Sri Lanka's statutory provision, anyone who commits this act of divulging information of a customer commits an offense. Offense is a criminal thing. Now, that payment of damages expected under Turnier's case is civil damages. සල්ලි කියවල වැඩේ ඉවර කරගන්න පුළුවන්. But here, this act of divulging customer information under the Banking Act is an offense. It's criminal. So I think these two things operate parallelly. In Sri Lanka, if a customer is satisfied that his information has been disclosed to unnecessary parties and bank is in breach of duty uh, in respect of the secrecy, but the customer should be in a position to file a case and obtain damages for the breach of contract. And also, customer is in a position to uh, initiate action to the regulator or law enforcement authorities because this is an offense. This is an offense. So those two things run parallelly. Now it's possible. I mean, let's just take the case of some parallel situation. Take the case of an accident, a road traffic related thing. One might, a driver might overrun a person by the kind of a the person who was working on the payment or something, right? Then what is the result? The he might sustain certain injuries. Uh, there may be a criminal case, traffic case, as you all refer to them, against the driver. The traffic case might result in that person found guilty and he must maybe asked to pay some fines. දඩ But at the same time, the person who was victimized, who met with this incident, if he has sustained injuries and suffered a loss, he can go to a civil court and file a case for damages. So the same driver might have to face these two uh, outcomes, right? Similarly, banker's secrecy, of course, violation of banker's secrecy might result in civil and criminal liability. That's what I wanted to tell, to show how serious the this duty is. I kept on talking. Any questions so far? No. So we'll go into the next slide. That is duty to provide statements of account. A customer has a right to receive a statement of account from the bank. However, the customers are not bound to read their statements. Remember Tai Hin Cotton Mill's case. Customer is not bound to read statements. Still, is entitled to obtain a receive a statement from the bank. Right? This Capital Rubber Estates Limited versus National Bank of India is a case where the incident is very similar to the tying cotton mills case. I think I have given all the points there. I don't want to describe that today. Again, yeah, you see tying cotton mills case as well because it's relevant here as well. You see, I'll take the last slide here. Uh, Privy Council decision. The Privy Council held against the bank on alleged duty to check the bank statements. The bank argued that the customer has a duty to read the statements. Privy Council held no. These are certain references from other countries. What are the other duties of a customer? Are there any other duties of the banker? You may remember, in addition to Macmillan's duty and the other one, I mentioned certain other duties on the part of the customer as well. Similarly, in the case of a banker, also in addition to the three main duties I mentioned, there are certain other duties. Duty not to pay checks without the authority of the customer. Duty to obey the customer's countermands of the checks. Duty to tell the customers of forgeries happen in the account. Duty to carry out its services for the customer with reasonable care and skill. Duty to act on notice of the death of the customer. What are those things? We check one by one and with the little details. Not to pay checks without the authority of the customer. That's correct, right? For example, if you see customer's signature has been forged by some party, what it means is that customer's real authority is not there. If you pay a check or in which the signature is forged, the customer is responsible for that because customer shall make the payment only if the relevant proper authority is there. Duty to obey the countermands of the checks. What is a countermand? It's kind of a stop payment order. What you do by way of a check is you demand the bank to pay. On the other hand, if you have a reason to stop that payment, you send a countermand, meaning that I have drawn this check, but don't pay. These are the details, check number and amount and things like that could be given. Then the customer is bound not to pay that check. That's a stop payment order in the ordinary terminology. The bank is not supposed to pay. Duty to tell the customer of forgeries. If there is a forgery into the kind of account of the customer, the banker is not bound to tell the customer that this kind of forgery has taken place. But you all practical bankers would know that the moment you tell the bank customer that there was a forgery, he would take it a very kind of a, I mean, depending on circumstances, of course. Uh, there can be little forgeries into some customers' accounts. I know practically a bank would look at that, and if the customer is not connected to the forgery, a bank is very likely to rectify the loss happen to the customer because bank's reputation is much more important than paying some amount to a customer. So the bank would generally make good of that loss and move forward. Generally, all the banks now consider, with the developed banking practices, generally banks consider it is important to keep the regulator informed. Uh, I know there are a lot of circumstances where even certain forgeries uh, took place in certain financial institutions. They immediately inform the central bank that, look here, we have come across this kind of forgery. We'll are going into that and we'll investigate and inform you. That's a good practice, and they that helps them to get out of unnecessary trouble, unnecessary questioning from the regulator, because they have informed it to the regulator beforehand, right? Duty to carry out service of a customer with reasonable care and skill. Yes, there should be reasonable care and skill on the part of the banker, because customers are parting with their money thinking that bankers would do a good job. Bankers will look after their money. Now, for that reason, custom bankers are supposed to exercise reasonable care and skill. Now, this is not a I told you that this is not a fiduciary relationship. This is not trustee and beneficiary relationship. Still, there are certain things, reasonable things expected of them. There is a duty of care that they owe. Otherwise, they might be held responsible for negligence. What is the duty of care? Because of the nature of the relationship between these two parties, bank and customer, there are certain expectations that the bankers would work in a particular way, but work with a particular set of responsibilities. That is the reasonable care and skill expected of them. Duty to act on notice of the death of the customer. What is it? When the customer is no more, when the customer dies, then the mandate of the customer to pay also come to an end. Now, if a customer has drawn a check last night, right, and given it to someone, and the customer has died this morning, if the banker is aware that the customer has died, then the bank should not pay that check. He may have signed it before his death, but with the death of the customer, that mandate comes to an end, right? Therefore, uh, bankers should not pay a check drawn by a person just before his death, right? Before his death, anyway. Now, this is the what I dealt with was the nature of the banker-customer relationship, the nature of the role of the banker and the customer, the nature of the relationship and duties and rights and obligations stemming from this relationship. Now, I told you, as much as this relationship can be explained as a contractual relationship between a debtor and a creditor, there can be other explanations. I would like you to look at these few examples, other relationships between bank and customer. Uh, Principal and agent. Customer may be acting as the principal of the bank. Then the bank is the agent. How does it happen? Customer is the one who orders the bank to pay checks. Who can give orders? It's the principal. Banker, as the agent of the customer, carry out those things. Just see what happens when standing orders are honored. When the customer gives a standing order, what he does is, as a principal, tells the agent, bank, my agent, make a payment on my behalf to my insurance company as insurance premium, or else make a payment to this utility company. You are my agent, you are paying that. So the relationship between the bank and customer can be classified as that of a principal and agent as well, right? You know that law principles governing rules governing principal and agent relationship would come into play. There are things like agent cannot work beyond the instructions of the principal. You, that kind of things are there. If the customer has uh, allowed the principal to make payment up to a particular ceiling, banker cannot pay more than that. So likewise, there are the agency law relationships, agency law principles that would be applicable to bank customer relationship in certain circumstances. Bailor and Bailey, as I mentioned earlier last week, there can be certain valuables kept with the bank. In those circumstances, there are things don't get commingled. Those things cannot get mixed up. Those things must be kept intact for the purpose of giving back to the customer. Uh, we took the examples of valuables kept in safety lockers as one clear example. Uh, One would argue that even articles pawned to the bank, I think someone mentioned that last week, should be kept by the banker intact, yes. Right? So this bail and bailee relationship is also there. In pawning, when the customer pawns his jewelries and get money back, they are again this relationship. Pawner and pawnee, person who pawns is the pawner and one who gets the valuables and gives money is the pawnee. This relationship is also can be extracted from the operations of the uh, bank and customer relationship. Mortgagor and mortgagee. When the customer wants to obtain a loan, customer would approach the bank and request for a loan. When the loan is granted, bank might tell him, look here, we are ready to give you the loan, but we need security. Security by way of a uh, property, mortgage. Then the customer is supposed to mortgage it. In that mortgage, customer acts as the mortgagor and the bank is the mortgagee. You'll see the same relationship takes different forms in these circumstances. Then these are certain rights available to bankers under common law. Bankers' right to set off, that is, right to set off when there are two accounts with uh, different balances. Customer bank is in a position to uh, set off what is due to the bank from an account where money is available, even if the customer has nominated the other account. It's subject to certain rules related to set off. Then right to charge interest, commission, etc. That is there. Then bank can obtain certain commissions and interest from the customer's account. Right to lien. Bank has a right to retain the property belonging to the customer until the debt due from him has been paid. Now, this banker's lien very often will take very simple examples. When a customer obtains a facility against a fixed deposit kept in the bank, bank might create a lien over the monies in the fixed account, fixed deposit. Right? I know the hilarious part is that when banks, I don't know then these 2 years it may not be would not have happened, but earlier when banks give these New Year gifts and so on, for keeping X amount of money in your account, uh, when the gift is given, money is subject to a lien, right? It's Sri Lanka's experience anyway. Liens can be created. Then the question is, how does the bank-customer relationship comes to an end? What is the end of the relationship? Right? It comes to an end uh, with mutual agreement. If the bank customer tells the bank, look here, uh, I don't want to be a customer anymore, so please give me my money back and I'll cease to be a customer. That's possible. Bank will have to give all the credit balances to the customer and relationship comes to an end. There are circumstances where termination can be initiated by the bank, where especially when the customer is dead, it automatically brings the relationship to an end. But banker can close the account and take necessary action, and especially should not make payments. If the customer has gone insane, right? If the customer is not of sound mind, banker needs to uh, take a decision and stop the relationship. And customer's insolvency. It's basically customer is after that supposed to be a person who cannot make uh, civil transactions, basically commercial transactions. He cannot enter into transactions. In those circumstances, banker need to know that relationship comes to an end. Customer can also terminate the contract uh, due to practical reasons, but customer doesn't have to take trouble. He can immediately inform the bank and terminate the relationship. Classical English law is that customer can immediately stop the relationship by giving not by informing the bank that I want to close the relationship. That's it. But generally, bankers were expected to wait, give notice sufficient for the customers to find out suitable banker. Right? That is the period where banking was supposed to be a very luxury thing, and not that everyone can open an account in the bank, and it was given to some privileged people. So that those days, banker was supposed to wait till the customer finds a suitable banker. Now you know what will happen if you close down the bank account with a particular bank. There would be 10 other banks approaching you to open an account with them. So these principles would not apply with the same rigor in present days, but the principle is same. I mean, uh, banker also can stop the relationship, but on reasonable grounds, giving reasonable notice and so on. Customers can just walk in and tell the bank, look here, I don't want to be a customer of yours. I'll cease to be a customer, right? That's it. So with that, we can stop the discussion on bank customer relationship, and we'll go into the second topic, which is negotiable instruments. Before that, any questions? I don't even know whether you are there.
Hello.
Yeah.
So one small concern that regarding to other duties of the bank. So
Yes.
in third point, it says duty to tell customer of forgeries. So as so a bank can disclose if there is any forgeries. Banker can disclose that to the customer in the first stage without having the investigation. So how the bank knows that the customer is not involved for this forgery. So in that case, are we allowed to inform the customer about this forgery? It's not that it tipping off in that case.
Yeah. It's a very good question. You are Chamini, right?
Yes, sir.
Yeah, yeah. This has different facets. That's why I stressed on the fact that generally a bank would act very prudently in this area, uh, and probably sometimes they would make the loss cost to the customer good and may go ahead and they keep the banks and regulator informed. I mentioned those 2 points, having this in mind. Now, informing a customer can be a duty to the extent that customer is affected. If the customer is affected, if someone has taken customer's money out, bank cannot keep quiet and let the customer lose money. He has to be informed. But as you said very correctly, it's subject to a lot of things. Probably this transaction may have taken place with the customer's kind of connivance or with the customer's participation. Then you cannot inform him and do something, basically spoil the entire process of investigations that is there. And also you use the word tipping off. That's very important. Now, tipping off would not generally something bad in the case of general transaction, general fraud, and things like that. But assume if it is connected to certain other legal obligations like uh, some sort of a crime which need to be reported to financial intelligence unit. If that is the case, if you are giving information to that person, you are doing tipping off, and tipping off is an offense there, right? So it is a very fine area. It's a very delicate area where you need to exercise due care, due, I mean, most of all, uh, above all, common sense, whether we should inform him or not. There are certain instances where a small amount of customers' money may have withdrawn by some other person. Then customer may not realize, but the bank realizes, and bank knows that it's purely uh, kind of a very small scale fraud that someone has done. In those circumstances, I would think that even the bank can move without informing the customer by and giving that amount to the customer, and loss may be caused to the bank. Probably, bank is might uh, recover the loss from the party who has done that, or even without that, bank can move alone. But general responsibility of informing the customer would arise if the customer is allowed to suffer the loss, customer is allowed to bear the loss. In those circumstances, again, of course, subject to the things that you mentioned, that is, you cannot be giving unnecessary information to the customer in such a way that you spoil your own investigations, or you are committing an offense by giving that information. That particular duty can be performed subject to those things only. Thank you for raising that. Is that
Thank
clear?
you, sir. Yes, sir. Thank you.
Now, this tipping off is not something very familiar to Sri Lankan culture. That is why there is a kind of a problem there. Now, for example, I might explain this when we go into the relevant topic. Now, as I mentioned now, if if an information is pertinent to something related to money laundering or terrorist financing, and if that is informed to the FIU under FTRA, then you cannot divulge that information to someone else. But very often we see places where certain institutions try to be very transparent and tell a lot of people that this kind of thing happened, we inform to the FIU, right? Yeah, not institution level, but officer level. They think that they have done something very good, and they should tell others that we are very good and things like that. That's very wrong. One should not be doing that. Even in official kind of communication, I very often get, not very often, sometimes get communication saying that we had this issue, then we immediately inform the financial intelligence unit, still this happened, and things like that. That part that they inform the FIU cannot be divulged to anyone. So, strictly speaking, they are doing an offense. That awareness is not there in our society, especially being little kind of keen to share that kind of information with everyone. Uh, we need to be very careful there. Yes.
Excuse me, sir, just one more question.
Yeah.
Say if a bank sees something suspicious or something which they may deem to be reported to the FIU, and but to establish the suspicion, they need a little bit more information to, and to do that, they may need to contact the customer. But if the customer is uncontactable all along, you spoke about yeah, we spoke about freezing orders by courts and things like that. But would the bank, can the bank like put a temporary debit freeze on the account, it's just with the only intention of like inducing the customer to contact the bank to get whatever information they want? Does the bank have the right to do that?
Yeah, so long as the contract permits. If the customer challenges that, then you may be sometimes you may not be able to justify your freeze on your own account, uh, just because he is not giving some information, you cannot stop him from withdrawing. But yeah, again, a very practical thing. If you have a suspicion, I think best course of action would be to keep the FIU informed so that you are doing your duty. And with the instructions of FIU, you can immediately freeze the account. But your concern is for you to inform the FIU, you are also not very much convinced whether this is something that need to be informed or you need to verify it with little bit of information from the customer. I
Exactly.
think the prudent practice would be waited for that little bit of information might put you into trouble, because if someone else reports or if FIU thinks that you are also keeping quiet until a particular situation, then probably the institution may be in trouble. So I think best course of action would be to l- let that information known to the relevant authorities like FIU at the initial step. The problem is, I know the practical problem is that if the customer's thing is informed like that, and if IU and financial intelligence goes on to freeze the account, and later on, with that additional information that you wanted, you find that it's totally an innocent transaction and you have unnecessarily disturbed the customer. Then he is not going to come back to you after that. You are running that risk in modern day banking, but I think when you weigh the risks of delaying the information communication to the FIU and I mean benefit of that and risk of that, I would think that any reasonable bank, especially considering the professional and personal impact on their personal and professional life, a reasonable banker would tend to inform. That may depend on your risk appetite and so on, but I would think that very likely a reasonable banker would like to inform in those circumstances beforehand. Is that satisfy? I mean,
Yes, sir, I do understand. It's just that the FIU stresses on the importance of submitting an updated KYC whenever a SDR is being filed. So to get that updated KYC, I think some banks have practical problems when sometimes the contact numbers are old, they have changed their contact numbers, not able to contact the customer. I think it's more like, as you said, sir, from a most practical perspective, banks tend to have an issue here. But I think
yeah,
it will be a case by case incident, as you
yeah.
say.
I know. I don't think that for last 2 3 years I have not worked very closely with FIU. I might check with them when it comes to relevant area. Now, for a kind of KYC update and things like that, it may not be advisable to have a freeze on temporary freeze on customer debits. That's my personal view. I'll have to check that and confirm.
Sure,
Right?
sir. Thank you very
You'll
much.
understand my difficulty. Generally, even though it is housed in the same central bank, we don't share information. I mean, if IU doesn't share information with us, we don't share information if unless it is SDR with them. Right?
Okay, so thank you.
Any other questions, please? Anyone? No. Okay, we'll go into the other topic. Maybe after some 20 minutes, we'll start at 10:30 then. Right? With this topic, which is negotiable instruments, uh, we'll see. Please look at this outline or arrangement of the presentation. So we are going to discuss what negotiable instruments are, and then we would go on to uh, negotiability and transferability concepts and features of negotiable instruments, as well as certain definitions that of the those of the bill of exchange, as well as a check and certain other things like parties to bill and types of bills and about checks, different crossings, and the protections available to paying banker and then to the collecting bank and so on, about endorsements and other things, and little bit about Payment and Settlement Systems Act and how it has changed the scope of the negotiable instruments and mostly checks in Sri Lanka. This is a definition of a negotiable instrument found in a classic English judgment, where an instrument is by the custom of trade transferable like cash by
Excuse me.
delivery. Whereas an instrument is by the custom of trade, where an instrument is by the custom of trade transferable like cash by delivery and is also capable of being sued upon by the person holding it, it is entitled to the name of the negotiable instrument. That is what is a negotiable instrument is. And the property in it passes to a transferee who has taken it for value and in good faith. Now, these words may not make much of sense when we look at them from very at this level, but we'll go into negotiable instruments in details and see what it means and whether we can kind of simplify the technical jargon in this topic in this description found in Crouch versus Credit Foncia of England. Uh, I would like to show you here the way Sri Lanka's legislation on base of exchange has been has come to the present status. Sri Lanka's statute governing bills of exchange is the Bills of Exchange Ordinance number 25 of 1927, and it has been amended on four occasions in 1930, 1955, 1957, and 1961. You see that the latest amendment to the Bills of Exchange Ordinance in Sri Lanka is 50 years old, 60 years old. It has been done in 1961. And one other interesting point would be just after the ordinance was enacted in 1927, in 1930, 3 years later, there has been an amendment to that. Again, in 25 years' time, there has been an amendment. Again, in 2 years' time, another amendment. Again, in 4 years' time, in 1961, another amendment. For some reason, we seem to be complacent with the law governing bills of exchange for last 60 years, and nothing has amended the bills of exchange ordinance as such. But there are developments in ICT, information and communication technology, and payment and settlement systems related law, which would, without amending the Bills of Exchange ordinance, may have taken certain drastic kind of turns, and therefore there may be certain differences. And what is most important for me to highlight here is that Sri Lanka's Bills of Exchange ordinance is based on the English statute, which is Bills of Exchange Act of UK. Now, Bills of Exchange Act and the Bills of Act of the UK and Bills of Exchange Act Ordinance of Sri Lanka are basically carbon copies. Now, this is something very common those days when Sri Lanka was under the British Empire. We used to have a lot of statutes in English law that were available in the UK as Sri Lanka's legislation as well. Certain, statutes which would look like carbon copies were enacted here in Sri Lanka. A classic example would be Bills of Exchange Ordinance of Sri Lanka. There are other things like Sale of Goods Ordinance in Sri Lanka, which is a copy of Sale of Goods Act of the UK. And similarly, there are a lot of other laws which are largely influenced by English law. Sri Lanka's penal code is coming from, Indian version of the penal code, which is influenced by English law. And evidence ordinance, again the same route, India, Sri Lanka, we took that in. And civil procedure code of Sri Lanka. Still, we have more than 120-year-old civil procedure code. Now, these were, in a way, time-tested legislation. At the same time, we need to understand that in the UK, especially the commercial transactions related legislation, changed very frequently whereas corresponding changes were not introduced in Sri Lanka in the recent 40, 50 years. That is what it makes Sri Lanka's law different from the UK law. Otherwise, it would have been the same law uh, for both countries. You'll see that scope of UK law was subject to considerable changes by statutes such as Checks Act of 1957. We did not have something corresponding to that, and that is why Sri Lanka's bills of exchange related legislation is very often criticized as not being updated to the level it has been updated in updated elsewhere. But in Sri Lanka also, this Payment and Settlement Systems Act of Act number 25 2005 introduced certain changes. I'll come to the changes that have been introduced by the Sri Lanka statute later. Before that, we'll go into the main topic and through these slides, of course. Negotiability and transferability need to be looked at. All negotiable instruments are transferable, but not all transferable instruments are negotiable. We'll go into check these statements in the context of technical points that would be discussed in the following slides. The term negotiability and transferability are often regarded as being synonymous. This is a misunderstanding. The fact that something is negotiable doesn't necessarily mean that it is transferable, right? Sorry, fact that something is considered negotiable instruments are transferable, but not all transferable instruments are negotiable. You see the third bullet point here, transferability relates to the process of passing title in an instrument. Negotiability usually relates to the quality of the title of the instrument that is passed. We'll come to the checks and other instruments and we'll discuss how that distinction is made. All these things are negotiable instruments that are given here. Bills of exchange, checks, promissory notes, bank drafts, dividend warrants, bearer debentures, treasury bills, all these things can be termed as negotiable instruments because they inherently have the nature of the negotiability. These are some examples of non-negotiable instruments. You see that although these look like negotiable instruments from prima facie, these are not really recognized by the courts of law, by the law, as negotiable instruments. The property and rights, the ownership of a negotiable instrument passes by delivery alone or by delivery and endorsement, as the case may be. That is, whether it's a bearer bond or otherwise, it would depend on that, which we'll discuss later. No further evidence of transfer is required. The holder of the instrument can sue in his own name. That is, the holder is entitled to do so. We'll again explain what it means. No notice has to be given to the debtor, the person who is liable to pay in respect of the instrument. This in suing this based on this kind of instrument, you need not to give notice to the person who drew it, the person who has really initially drawn it, or even to the person who will be liable to pay. Consideration is presumed to have been given for the instrument. Now, if you have a check with you, you don't have to prove that you have given the consideration to receive that check, right? And it is necessarily presumed. A negotiable instrument is transferred free of equities, meaning that a transferee obtains a good title to the instruments, all the transferor's title was defective. In certain circumstances, this may be affected. We'll discuss them. Generally, in the case of a negotiable instrument, the transferee gets a good title irrespective of the title defects in the transfer. We'll go into simple details first and then explain these concepts. Now, this is the definition of a bill of exchange found in the bills of exchange ordinance. You see that I have put that broken that into 6 different parts uh, for ease of understanding. Right? The bill of exchange is, what is it? An unconditional order in writing. That's the first part. Addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determined future time a sum of some certain in money to owe. It should be to owe to the order of a specified person or to bearer. Now, point number 6 should be to owe to the order of a specified person or to bearer, meaning to the specified person or to the order of a specified person. You need to put the word to after O. 6 would read as to owe to the order of a specified person or to bearer. Right? We'll see what these things are. Firstly, a negotiable a bill of exchange need to be an unconditional order in writing. It need to be an unconditional order in writing. It must be an order that is something in the nature of a command. Examples: pay, please pay. Right? This is not a request. Right? It's always an order. That order need to be unconditional. It should be unqualified. There cannot be conditions attached to the order. You'll see there are 2 examples given. An order to pay out of a particular fund is not unconditional as there is a condition to be fulfilled. The money available just forget about this slide. I think my colleague has included something. There seems to be some sort of kind of a thing dropped here in the first point. We'll omit, basically forget about that and go on. This slide again on unconditional order. In this case, it was held that the order must be unconditional. An order to a banker to pay, provided the receipt from the foot hereof is duly signed, will not be a bill of exchange. The banker is ordered to pay only if a condition is fulfilled by the payee, namely signing the form before the banker can pay. It is not an unconditional order to pay. I'll take a very simple example. If you give an order to someone, pay 1,000 rupees if the goods are delivered, right? Take that, pay 1,000 rupees if the goods have been delivered. That is not going to be an unconditional order, because that payment would be necessary only if goods have arrived. So it's not an unconditional order. Pay 1,000 rupees if you are satisfied with the service. No, it's not an unconditional order. Pay, say, some amount subject to approval of so and so. Those are not unconditional orders. There cannot be conditions attached to this order Order is not a request. Order is not something else. It's an order, but it need to be unconditional as well. There cannot be conditions attached to the order. And also, this thing needs to be in writing. You may remember an unconditional order in writing. It's there in the first element itself. What does it mean? The whole of the order in the instrument must be in writing. The word in writing includes what is typed, printed, or written. Uh, that we'll find in the definitions of the bills of exchange itself. But for the time being, we'll go on that the entire thing, entire order needs to be in writing. It cannot be partly written and partly verbal or something like that. The written uh, can include typed, printed, or written. That's okay. Uh, then, as we saw in slide number 12, an unconditional order in writing addressed by one person to another, right? This order needs to be addressed by one person to another and signed by the person giving it. uh, yeah, we'll take before this, one person to another. Probably there can be situations where now it shows on the face of it, it's very difficult to tell you certain things without going into details of checks. We'll figure out them when we go into checks. As you know, that there is when it comes to bill of exchange, there is a person who has drawn it. Now, if you take the check, take the example of a check, which is the most common bill of exchange that you would come across. The person who draws the check, the drawer, and there is an intended party on whom the check is drawn, the drawee. And also, there is a party to whom the payment should go. There is a payee. Now, if I'm a customer of a particular bank, say Bank of Ceylon, and Bank of Ceylon may have given me a checkbook. Whenever I draw a check using one of those check leaves, what I do is that I'm giving an order to Bank of Ceylon, meaning that I'm drawing a check on Bank of Ceylon. So I'm the drawer. Bank of Ceylon is the drawee. That is the party to whom the order is addressed, on whom the check is drawn. So that in the bill of exchange, there is a person who draws it, drawer, and drawee to whom it is addressed, right? And I tell the bank, I order Bank of Ceylon to pay X thousand rupees. Then X is the payee, right? So generally, a bill of exchange is an unconditional order in writing. Unconditional order in writing, addressed by one person to another. Addressed by one person to another, right? So one person addresses it to someone. In my example, if I have an account with Bank of Ceylon, I have a checkbook issued by them. Whenever I draw a check, I am addressing something to Bank of Ceylon, addressed by me. Addressee is Bank of Ceylon, addressed by one person to another, right? Now, can there be a case where addressor, the person who addresses, and addressee can be the same party? Can there be an example? The person who draws the check as well as the person on whom the check is drawn are the same party. Can you figure out a situation like that?
Pay orders.
Pay orders, bankers, bank drafts. Sometimes we call managers checks. Bank issues a check on themselves. Bank manager or someone would sign. It's a pay order on them, drawn on them. That is why when it comes to commercial transactions, sometimes people rely on pay orders or bank drafts or managers checks. Where the risk of a third party pay drawer default in the payment would not arise because the payee, the drawee, and the drawer are the same party. So when the bills of exchange ordinance says an unconditional order in writing addressed by one person to another, probably there are no two persons here. It can be the same person to the that person himself. This address may be like that in the case of a order like this, right? Having said that, we'll move on to the next requirement, signed by the person giving it. The bill of exchange must be signed by the drawer. The person who issues it has to sign. If it is sufficient, however, if the bill is signed by some duly authorized person on behalf of the drawer. That is the classic law relating to bills of exchange. Forged checks are not bills of exchange because the reason being it has not been signed by the person giving it. It is purportedly signed by the person giving it, but actually not. That is why sometimes this argument comes up that a forged check is not really a bill of exchange. It's there. It cannot be valid, right? Uh, so there is a requirement that it need to be signed. What is the message given in the bill of exchange? Requiring the person to whom it is addressed to pay on pay. Requiring the person to whom it is addressed to pay. Now that person is asked to pay, right? When I'm drawing a check on check on the Bank of Ceylon, what I'm asking the Bank of Ceylon is to pay, requiring the person to whom it is addressed to pay. What is the time point at which this has to be paid? Pay, right? Pay on demand or at a we'll go to section slide number 12. Address to pay on demand or at a fixed or determinable future time. So there are three occasions in which this payment can be made. Look at number 4 here very closely. Requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time. So it can be on demand, it can be at a fixed time, or at a determinable future time, right? All three things are there. You see that I'm little struggling with certain slides. Reason being, I asked one of my colleagues to take my slides and do whatever changes. She has done a lot of changes. Probably those things I couldn't go through them earlier on before I open it for you. My line of thinking and those what is described in slides may be a little different, but I'll try to be natural as much as possible. Requiring the person to whom it is addressed to pay not only on demand, on three different alternative instances. One is pay on demand, or pay at a fixed time, or pay at a determinable future time, right? The requirement refers to time of payment. Bill is payable. Yeah, I'll go into that later. Forget about the second bullet point here, right? It can be something payable on demand, or at a determinable future time, or at a fixed time. It is also dealt with. A determinable future time may be a stipulated period after a date, or after sight, or after the occurrence of some event which is certain to happen, right? But payment cannot depend on contingency, even if the event should occur. A document expressed to be payable 6 days after the ship named Sea Lion leaves Colombo Harbor is not good bill of exchange because a specified event might not happen. But you can connect it to a specified event that will happen and that the date may be a determinable future time, right? Then we go on to the next level. The bill of exchange is supposed to be an unconditional order in writing, addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time, a sum certain in money. So someone is drawing a bill addressed to another in writing, asking that person to pay on demand or at a fixed or determinable future time. What? A sum certain in money. It should be a sum certain in money. The sum payable is certain, although it is required to be paid with interest. It can be by installments or something like that. But the sum is certain, right? That is the nature of a content, I mean, subject matter of a bill of exchange. It cannot be anything else. It need to be money, a sum certain in money, right? Then, to whom requiring the person to pay sums of money, to whom it is payable. We'll go to slide number 12 again and see to owe to the order of a specified person or to bearer. Here again, there are three combinations found. That order may be an order in write, unconditional order in writing, addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money that has to be paid to whom? To a specified person. Number one, to a specified person. Number two, to the order of a specified person. Number three, to a bearer. You'll see that this now component number 6 in this slide has three different parties who could be the payee. That is, some certain in money is paid to a specified person, to the order of a specified person, or to the bearer. Now, just I find it little difficult to present without some kind of drawings and so on, but I'll go on to explain now. Can you see my slides, please? Something happened, I believe. Can you see my slides?
Yes, sir. Slide number 12.
12 is there, right? Thank you. Now this can be to or to the order of a specified person or to the bearer. What it means is, now I'll take my example again. I'm drawing a check on the check leaf issued by Bank of Ceylon, meaning that I'm the drawer, Bank of Ceylon is the drawee. You can remember the way it is written in on a check. Pay, then there is a blank. Pay X. I would say pay X. 1,000 rupees. I'm asking the Bank of Ceylon, to pay X 1,000 rupees. When I say X, it's a name. Pay someone, or somebody. Pay X 1,000 rupees. What is my order? I'm ordering the bank to pay a sum certain in money to a specified person. Who is that person? Mr. X, right? So I'm ordering my bank to pay that amount to a specified person. Or else my check can be written as pay X or order 1,000 rupees. Then they are not only X's order is also there. Order meaning that if X orders, if X passes it on, if X endorses it to someone else, that person also can be entitled to be the payee. That person might will be the beneficiary of the order I'm making to order I'm given to Bank of Ceylon. So you see that it can be the person to whom that specified person to whose name is specified on the check, or it can be his order, the any person ordered by, permitted by him, to whom he has endorsed his check. And also, we can write the check as pay X or bearer, right? We can let any bearer, any person who bears, any person who brings that check to be the beneficiary of the check. So you will see that in general, bill of exchange is drawn on a particular party by another party, right? I told you that it can be the same party in certain instances, but generally a bill of exchange is drawn by a particular party on another party, asking that party to pay some certain in money at those given circumstances to the specified person or to the order of the specified person or to the bearer. There are three possible potential payees here. The payment can go to one of them, right? That is the nature of a bill of exchange. Uh, Again, can you see the slides? I think
Still in slide number 12, sir.
that doesn't move for some reason again. Hope we are moving, right?
Yes, sir.
Thank you. This is what we were discussing. It can be a specified person, the order of a specified person, or the bearer can be the payee, the beneficiary of a check, bill. Uh, then it goes without saying that parties need to have the capacity to be a party to a bill of exchange. Capacity to incur liability as a party to a bill is coextensive with the capacity of contract. That basically capacity to contract should be what is required in a bill of exchange as well. Such capacity is to be determined by law of Sri Lanka in the case of Sri Lankan the instruments. It shall be determined by Roman Dutch law as administered in Sri Lanka, because the law of contract in Sri Lanka is law of Roman Dutch law. Uh, if there is another statutory law governing that area, that might take precedence. But generally Roman Dutch law, but we don't have to be worried. Generally, any person who can enter into a contract can enter into a transaction concerning bill of exchange, meaning that issuer, meaning drawer, drawee, as well as payee need to be having contractual capacity. Here again, little bit of complex information at this point. This may be necessary in future discussions. Consideration is a valuable part, but we'll go on. Uh, we'll take these simple things and later on come to other parts. Uh, as I mentioned earlier, there are three parties to a bill: the drawer, drawee, and payee. The drawer is the person who gives the order, drawee is the person to whom the order is given, and the payee is the person to whom the bill is payable. Uh, Before I go into order bills and bearer bills and so on, I would like to take the checks as well, because the definition of a check is again related to the definition of a bill of exchange. You'll see that section 73 of the Bills of Exchange Ordinance defines what a check is. It says a check is a bill of exchange drawn on a banker payable on demand. Now, I would like you to see how this particular definition is different from the definition of a bill of exchange given in section 3 of the Bills of Exchange Ordinance. Now, you would see section 3 of the Bills of Exchange Ordinance said a lot of things. Like what? It said a bill of exchange is, what is it? An unconditional order in writing addressed by one person to another, signed by the person giving it, and requiring the person to whom it is drawn to pay on demand or at a fixed or at a determinable future time a sum certain in money to owe to the order of a specified person or to a bearer. Now that was the definition given there in the section 3 of the Bills of Exchange Ordinance. Now here section 73 defines bill of exchange as a check. A bill of a check as a bill of exchange drawn on a banker payable on demand. You will see some sort of a connection. We define a bill of exchange, and the check includes the definition of a check gives reference to a bill of exchange when it says a check is a bill of exchange drawn on a banker on demand. Now, when you compare this one with the definition of a negotiable instrument that we discussed earlier, which we broke into 6 different components, you must be seeing some sort of a relationship with that definition. Basically, in the first place, this refers to bills of exchange. So a check is necessarily a bill of exchange, but all the bills are not checks. There can be bills of exchange which are not checks. You saw the list of bills. Now, but all the checks are bills. That's what this definition says. A check is a bill of exchange drawn on a banker payable on demand. Now, what is it? Check is a bill of exchange and it goes on to say drawn on a banker payable on demand. Now, when you compare this definition with the definition of a bill of exchange, what do you think? How many areas of the earlier definition are going to be affected by this definition? Look at the earlier definition. A bill of exchange is an unconditional order in writing addressed by one person to another. Right? Likewise, it goes on. Now, here, there is a simple definition. What do you think? Can anyone just tell me how many critical elements of the first definition, that is, definition of a bill of exchange, have been changed by this one? We'll take probably those things one by one. I'll take the first one. A bill of exchange is an unconditional order in writing. Unconditional order in writing. Is it affected by this definition? Does it say something otherwise or something to the contrary effect? Right? You won't see anything contrary. A check is also an order, unconditional order in writing. There is nothing to the contrary intention. So, what is the next component of a bill of exchange? First one, an unconditional order in writing addressed by one person to another. Addressed by one person to another. Is it fully accepted here or is there a difference? A bill of exchange is something addressed by one person to another. Here, this definition says a check is a bill of exchange drawn on a banker payable on demand. Is there something that kind of there's an interrelationship between these two things? I would like someone to speak. Any interrelationship between these two things? Look at what is in slide 12 and this one. Any idea?
In section 3, the definition, it's a broad definition. It says address from one person to another, but in section 73, it's more specific, and it says it's drawn on a bank.
Exactly. Thank you. You'll see that section 3 recognizes that a bill of exchange can be drawn by one person to another. It can be any two persons can be connected as drawer and drawee. When I say that I draw a check on Bank of Ceylon, what I mean is that I'm drawer and Bank of Ceylon is a drawee. But here, that is the general definition of bill of exchange. But here it is specific. A check is a bill of exchange drawn on a banker payable on demand. When you say drawn on a banker, the addressee of the order, the person to whom it is drawn, the drawee, is certain. Hey, it's a bank. It's a banker. It's a banker. It's a bank always. Now, on the other hand, it is implied that who can give an order to the bank? An order to the bank can be given only by a customer of the bank. If I give an order to some bank where I don't have an account, they are not going to pay, right? So the two persons, the addressor and the addressee, in the bill in a ordinary bill of exchange can be any two parties. But here, the addressee, the drawee, should always be a banker. What it means is that the drawer is a customer. Others can't draw bills on a bank, right? So, yeah, correct that we can go on to say that this particular requirement addressed by one person to another is not if reflected in the definition of a check. That is something that makes a check something narrower than a broad definition of bills of exchange. Then we have the other components addressed by one person to another. What is the third one? Requiring the person to whom addressed. Is it the third component or fourth component?
Signed by
Signed by
person
the
giving.
person given it.
Yeah, yes, signed by the person giving it. This definition doesn't have anything to contrary effect. signed by requirement is not here. It is silent, but it is presumed because it should be a bill of exchange. So it's signed by parties necessarily generally included here, but there is no special reference. But what is the fourth requirement? Signed by a person giving it and requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time. What is the requirement here? In the case of a check is a bill of exchange drawn on a banker payable on demand. Now again, you will see a difference here. What is the difference? A bill of exchange is a instrument where the addressee can be re- required to make the payment on demand or at a determinable future time or at a fixed time. But in the case of a check, it is not at a fixed time or not at a determinable future time, but it's always on demand, right? So you'll see that here the check is again a subset. In the case of a bill of exchange, addressor and addressee could have been any two parties. But when it comes to a check, it's only addressed to a banker. It means that it can be addressed by the customer of the bank. And also, in the case of a bill of exchange, the payment can be required to be made on demand or at a fixed time or at a determinable future time. But you will see in this one, it's always payable on demand. That is why we call it demand deposit. You may remember last week I was going into a lot of things about different types of accounts and why current accounts are necessary and why are they called demand deposits. Now you'll see why it is called demand deposits. Checks can be issued asking the person to pay make the payment on demand. You see that we don't have to go into other elements of a bill of exchange, because now you see that when we have exhausted the word in this section with this definition, which says a bill of exchange is a check is a bill of exchange drawn on a banker payable on demand. So since all the words here in this definition have been discussed, we don't have to go back to the definition of a bill of exchange and recheck other elements. Now you see that bills are different from checks. All the checks are bills, but not the other way around. Check is different from a bill from two aspects. One is the drawee, and the other one is the payable time, right? That is why we can call that checks are a kind of a subset of the broader set called negotiable instruments. Negotiable instrument කියන එක ඇතුලේ තමයි checks තියෙන්නේ. අනිත් පැත්තට තියෙන බෑ. Checks are a kind of a subset of the set called negotiable instruments, right? That we need to understand before going into other areas. Can you see slide number 31? Can you see slide number 31? A valid check must satisfy the following conditions.
Yes, sir.
Yes, sir.
Right, thank you. It's a little disturbing to ask you every time, but I have some sort of a issue here. Can't see. So now this is basically a summary of what I just said. A check must be an unconditional order in writing, taken from the definition of a bill of exchange. It must be signed by the drawer, the person giving it, because it cannot be any other person. It must be drawn on a banker. Yes. It must order the bank to pay a sum certain in money on demand, not otherwise, not at a fixed time or not at a determinable future time, but on demand. It must be drawn in favor of a specified person, the payee, or in his to his order, or in favor of the bearer. It can be all three options given in the definition of bill of exchange. But those two conditions, that person to on whom it is drawn is always a bank, and the payable amount time is always on demand, right? Those are the two differences that would significantly change general bill of exchange from a check. That brings us to types of crossings. Before that, I left 2 3 slides just to come to checks so that we can go back to them. Now here, types of bills. We recognize in the law relating to negotiable instruments, bills of exchange, there are two types of bills, which are called bills, order bills, and bearer bills. These two types are described in sections 8, section 8.3 and 8.4. 8.3, sorry, 8.4 describes an order bill as a bill, a bill is payable to order, which is expressed to be so payable, or which is expressed to be payable to a order to a particular person, right? A bill is payable to order. It doesn't use the word order bill, but a bill is payable to order is an order bill. An order bill is expressed to be so payable, or which is expressed to be payable to a particular person. So what it means is that if your bill says that it's payable to order, it's definitely an order bill. And also, if your bill says pay to a specified a particular person, that again is an order bill, right? So there are two circumstances where a bill is an order bill. Those are given here. Give me 2 3 minutes. Please. The we were at types of bills. Yes, a bill is said to be an order bill if the bill itself says that it's an order bill, or the bill is expressed to be payable to a particular person. Now, if the bill contains the words or order, it would necessarily mean that this particular bill is an order bill. Or if the bill says, if the bill states a name of a particular person, in this example X, what it means is that again the bill is payable to order. It's an order bill. On the other hand, what is described in section 8 subsection 3 is that if the bill is if the bill indicates that it's payable to bearer, that is, if it contains the word pay to bearer or bearer, right, then it's an order bill. Or on which only or last endorsement is an endorsement in blank. Now, how do I explain? If the bill is drawn on a particular person, particular entity or drawee, and it's payable to someone, that payee can endorse it to someone else. That person can endorse it to someone else. then it can go on likewise. Rather than endorsing it to someone else, if that person puts an endorsement in blank, meaning that he endorses it, anyone can take the proceeds of the bill. Then it becomes a bearer bill. I'll take an example and two, three examples and explain. Just imagine that for me to do this, I need your participation. Then only I can, I mean, see whether you get the point. Just imagine that I draw a check. I draw a check to the effect to say pay X thousand rupees, right? Pay X thousand rupees. Is it an order bill or a bearer bill? Anyone can answer. Is it an order bill or a bearer bill?
Audible.
Order bill.
It's an order bill. Yeah, good. I say pay X or order. Is it an order bill or a bearer bill?
Audible.
It's an order bill, right? I say pay X or bearer. It is an order bill or a bearer bill?
Bearable.
Bearer bill.
It's a bearer bill. Because even if the name of a specified person is there, it's followed by the words or bearer. It's a bearer bill, necessarily. Then I come to the other part. I draw up a check on a particular entity or bank or whatever person, and I mention it as pay X, right? Pay X. Is it an order bill or a bearer bill? We answered this question earlier. Pay X. What is it? It's an order.
bill.
Yeah. X endorses the bill to Y, right? I have drawn a bill payable to X. Now X has endorsed it to Y. What is the nature of the bill now? Is it an order bill or a bearer bill?
Bearable.
Bearable.
Is it? Now, why do we call it an order bill? I have specified the person.
No,
So in
still it's an order bill because it has been
It's an order bill.
specifically
Yes.
specified to Y.
exactly. What is an order bill? I have specified a person called X. Now X has endorsed it to Y, meaning that now the specified person is not X but Y. Still there is a specified person. Now it has been endorsed to a specified person. So the nature doesn't change. Still, it's an order bill. Now imagine Y endorses it, Y endorses the bill without mentioning the name of any other party to whom it is endorsed. It has been endorsed, but there is no endorsee, which we call an endorsement in blank. Now, what is the position of the bill?
This
It's
is a
an order bill.
bearable.
Bearable.
Now it
The
is a
bearer bill.
now
Bearable.
it's a bearer bill. Then you see the explanation. So a payable or on which the only or last endorsement is an endorsement in blank. Now our example. Now this Y, the X endorse it to Y endorse it without a name, meaning that it's a blank endorsement. So it has become a bearer bill. Can it become an order bill again? Can it become an order bill again? Will it remain to be a bearer bill for the rest of its lifetime? Or can it become an order bill as well?
Can become as far as endorsement is there.
Which endorsement? Who is supposed to endorse? Now, X endorse it to Y endorse it in blank. Yeah, you are correct.
Y has to.
Y or even some other person, because Y has already endorsed it to endorse it in blank, right? Now, anyone who gets a bill while it is a bearer bill, because there is a blank endorsement, can endorse it again, giving a name or not giving a name. I mean, endorsement can be done into a name with an endorsee or without a particular endorsee. Again, blank. If the endorsement is done into the name of a particular person, then that bill ceases to be a bearer bill and it again becomes an order bill. I think that's what you wanted to say. But the endorsement can come from anyone because Y has opened it up to anyone by giving a blank endorsement. What I want to do, the point I want to draw is that even a bearer bill can become an order bill. Now we'll take the simple thing. You have a check which says pay XO bearer, right? What is it? It's a bearer bill or an order bill?
It's a bearer bill.
Variable.
It's a bearer bill. Now to make that bearer bill an order bill, what do you do? What can you do? The wording given is like what is in the last few words in this slide. Pay XO bearer. What do you do to make it an order bill? What if you cut off the words O bearer? Huh? It should become an order bill. Right? Now this is a kind of bit of a technical exercise, but you need to have this in mind because this has something to do with certain obligations of bankers when it comes to bankers' responsibility and how bankers are getting some immunities in the law of bills of exchange. This need to be this has some sort of a bearing. Now this kind of online teaching doesn't allow me to explain it in certain other ways. But while I was asking these questions, when you all started giving answers, something came to my mind. I used to, I can't remember when, at least some 8 years ago, when I was discussing this topic with IBSL students, that was, I think, in a very preliminary class, maybe. I asked them, I changed this wording from time to time, and I would ask what is pay X, what is pay X order, what is pay X bearer, or blank endorsement, another's endorsement, and likewise I asked them what is it, and then I would ask it is a then they would say bearer bill. So it's either bearer bill or an order bill. So I kept on saying or an. It's necessary I'm giving an indication. If I say it's an, it's going to be order bill. It's a going to be bearer bill. I think those students, for some reason, when I say an, yeah, they naturally say order bill. Then I would tell them pay X or bearer. Pay X or bearer. What is it? It's an කියපු ගමන් ඔක්කොම order bill කියනවා. අර it's an කිව්වම ඒක ගන්නවා. So that it just came into my mind. Practical, I mean, the one-on-one, I mean, face-to-face teaching and doing something online is totally different, right? Anyway, if you can, if you have questions in this area, you can ask at any point of time. I left out certain slides because that would disturb my flow. A lot of information, but may not be in the my thinking order. I think we are on the next slide. I again had to take it. Fundamental distinction between bearer bill and order bill. This is what is connected from the previous slide. Uh, when there is an order bill, the operation of it is slightly different to uh, it's basically different to the operation of uh, the other type order and bearer bills are working in two different ways. Uh, Here, a bill payable to bearer is negotiated by delivery. A bill payable to bearer is negotiated by delivery. On the other hand, a bill payable to order is negotiated by the endorsement of the holder completed by delivery. What it means is that if you have a bearer bill, you can simply give it to someone just by giving it. What I mean is technically, legally, delivery. By delivery, uh, you can complete the negotiation of a bill in legal terms. On the other hand, if the bill is an order bill, it cannot be negotiated by mere delivery or giving it to someone else, but it should be endorsement of the holder completed by delivery. Holder needs to endorse it and deliver it. Then only negotiation take place in the case of an order bill. Now, this is important as far as the legal argument is concerned. What is this rationale? If it's a bearer bill, what it means is that any bearer can have title to it. So if you want to negotiate title, if you want to pass on your title in such a manner recognized in law that you are passing the title, what you can have to do is just give it to someone, deliver it to someone. But that is not the case with an order bill, because in the order bill, the payee is specified. If the pay is specified, you cannot deliver it to someone. Even if you deliver without an endorsement, what it means is that there is no negotiation, because the person who receives the bill cannot be entitled to the rights of the bill, right? So you see that negotiation happens in two different ways in respect of two categories of bills. Now I come to crossings of bills, crossings of checks. Do you see this slide? Slide number 32.
Yes, sir.
Yes, sir.
Right. Crossings. In the law governing bills of exchange, basically in our context, bills of exchange ordinance recognizes two major types of crossings. One is a general crossing, recognized in section 76(1), which says where a check bears across its face an addition of two parallel transverse lines, either with or without the words not negotiable, it's a general crossing. It's a general crossing. When you see two transverse parallel lines on the face of a check leaf, you know these things are uh, general crossings, right? We'll see the effect of a general crossing and a special crossing. These are general crossings. These kind of two lines with and company name of a thing, account pay only, not negotiable. So when you see two transverse parallel lines, either with or without the words not negotiable, it is a general crossing. Compared to that, you get a special crossing defined in section 76(2), which says that where a check bears on its face an addition of the name of a banker with or without the word not negotiable, that addition constitutes a special crossing. There are examples given. Bank of Ceylon. It is the name of a bank given on the face of a check leaf in between two transparent lines, which means it is a special proceed. The name of a bank is given. You'll see number two, not negotiable. The words not negotiable are there. With him, there is a name of a bank, People's Bank. That again is a special proceed. Number three, account pay only, Bank of People's Bank, Vellavatha. Now, when you see an account pay only crossing, in general, it may not be a real crossing as well, but we never consider it as a special crossing. But if those words are accompanied by the words by the name of a bank, then what it means is that it's a special crossing. You see that the fourth one, there is a number given, some sort of a limitation of the value, as well as the name of a bank. So what is crucial here is that if you have given the name of a bank in the crossing, it is a special crossing, right? Then we'll see what is the effect of a crossing on a check. Before that, now this is the effect of a not negotiable crossing on holder. Before that, what we'll consider what really a crossing would mean. When you get a crossing, maybe it's a general crossing or a special crossing, whichever it is. If you have got a cross check, what it means is that in banking practice, you cannot get it encashed over the counter. That cross check need to go through a bank. It has to be presented through a collecting bank for the value. Now, it can be a general crossing or special crossing. Where there is a crossing, there is a reservation, that is that it cannot be presented over counter and get it encashed. It has to go through the clearinghouse, right? On the other hand, when you have a special crossing, it must mean that that has to be presented to that specially named bank only. Now, in these examples, in the first example and fourth example, that has to go to Bank of Ceylon. In the fourth example, Bank of Ceylon Jaffna branch only. In second example, it should be People's Bank only, and in the third example, it should be People's Bank, Vellavatha. Likewise, you name the party to whom it should be presented. You name the collecting bank as well. That kind of a crossing is a special crossing. Here again, no difference. That has to be presented to, that has to be, this cannot be exchanged, encashed over the counter. It has to be deposited into an account. Then, having said that, we'll go on to the effect of the words not negotiable on the crossing of a hold, on the crossing. In the crossing on the holder. How does it affect the rights of the holder? This is what is given in section 81 of the Bills of Exchange Ordinance. It says, where a person takes a cross check which bears on it the words not negotiable, he shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. Meaning, when a person receives a check with the words not negotiable, his title or any person who gets that a title of any person who gets that check from him cannot be better than the title of the person from whom he received it. Now, we'll take a simple example. I can draw it anywhere. So imagine that there is a check drawn by someone, drawn on a particular bank, and the payee is a person called A. You know that this is an order check, order bill. Now, this is crossed with the words not negotiable, right? That drawer, who it was, has given this check to A with the words not negotiable. Now, A cannot have any title. Now, I'll go one step ahead. Then A gives that check to a person called B with an endorsement. That not negotiable clause is still there. Now B, what is B's position? B's position is that he got something from A which he is having now. What is the nature of the title to that bill? In the case of B, he cannot have any title better than the title of A because he got it from A with the words not negotiable. Now B has the check. B's title cannot be better than whatever the title A had in that check. Whatever the defects there were in the case of A have been passed on to B. We cannot have anything better than that in that check. And also, if B wants to pass it on to C with an endorsement, he cannot give C any better title than that of A because of this section. This section says any person cannot have and cannot give any better title to the check, right, than the title of the person from whom he took it had in that check, right? So A got a check from somebody, A is the payee, A endorses this check bears the crossing not negotiable, A endorses it to B, B gets what A had, and B gives what A gave him, right? So in the case of C, all what he gets is what B had, right? So all what B had was all what A had. Now, the person who drew the check, when he put the term not negotiable, he's in a way protecting himself because the last person who is holding the check after several endorsement, several negotiations, will again subject to whichever point he is getting what the previous person had. He is getting what the previous person had. Likewise, it comes to the drawer. There cannot be anything. There cannot be unnecessary liabilities on the part of the drawer, since this the crossing protects him. When you see the term not negotiable, you might think something. I mean, bankers are familiar with that. No, any adult would be familiar with this. But when you see it, that as if this check cannot be negotiated anymore. No, it's not the case. Practically, you can negotiate it, but you cannot give anything better than what you have in that check, right? What it means. That's what it means. Any question on that? You may have seen that I was little hesitant when I was taking that example, and when I use the title of A, the first person, he is not an endorsee, but he is the payee. That from that particular initial point, there has been some debates in English judiciary. I didn't want to get into that difficult area without going into that. That's why I avoided A and went on to B, right? Whether that negotiable has the same effect on the first person is little debatable. But generally, the effect of a not negotiable crossing is that it basically prevents any new holder getting anything more than the earlier holder had. The issue with A, which I didn't want to discuss, is that A is not an endorsee. A is the original payee, right? Whether his rights also can be curtailed is little debatable. Are we clear there? Are there any problems? Any questions? Then we will go into the next part, that is account pay only crossing. Now, you know that what is a check? A check is an instrument whereby you, the drawer, gives an order to your bank. So it carries your message, your order. You say pay X, so bank is liable to pay X. You say pay X or order, so your bank is liable to pay X or even its order. All because, not because of excess order, but because you as the original customer, drawer, you wanted the bank to pay X or excess order. All these authorities emanating from your initial action as the account holder, drawer. Now you are giving instructions to whom it should be payable. X or excess order, meaning Y is a door. Anyone can be the payee. Similarly, you give orders, 1,000 rupees. So your bank is going to pay 1,000 rupees. Whoever who is going to be the payee after the endorsements, he is not going to pay anything more than 1,000 rupees because the bank is honoring you, right? Your order. So why all these instructions in the check leaf are given by the customer to the bank? That is why we said banker customer relationship can be explained as a principal agent relationship where the customer gives orders as the principal and the bank receives them as the agent. Now you have given a lot of things to your bank uh, to be vigilant. You give him the name of the payee. You give him your banker the amount payable. You place your signature, which the bank has to verify, and if the bank pays based on a wrong signature, bank is liable for that, and all that is there. So your bank is little restricted from your instructions. What is the effect of the crossing account pay only? Can someone explain it to me? I'm not being a commercial bank. I really don't know the exact operation. What is the effect of account pay only? Can someone please explain? I give an idea.
It is an instruction to the collecting bank, sir.
It's an instruction to the instruction to.
The collecting bank.
Yeah, exactly. Very good. That's what I wanted to arrive at. What is the effect of that? What is really meant by the crossing account pay only? What is this instruction? Can someone explain the effect of this? It's an instruction to the collecting bank. That's correct.
The check cannot be encashed at the counter.
Yeah, that is there in the case of any crossing. So this
And
is
that
a
the,
crossing that is there. But the special effect of these words, account pay only. What is it?
that the funds need to be paid into an account in the name of that particular payee.
Exactly. That particular pay's account has to be the account to which the funds are collected. Now, that can be ensured by whom? Only by the collecting banker, the place where the check is going to be deposited. But to whom the original drawer of the check gave the order, it is to the paying bank. Normally, in the case of a check, the crossing, who can who will look at the crossing and ensure that it is a paying bank. Just imagine your day-to-day practices. When the checks go to the clearing house and come back to you, come back to the paying bank. If it's the officers of the paying bank who look at the crossings and see the validity, right? Now, this particular crossing, can it be verified by the paying bank? Because it has been deposited into an account of the collecting bank. Can this crossing be practically examined by the people at the paying bank? In your example, what is it?
No.
No. Then how should you ensure, how do you ensure that you are paying it correctly? It's your responsibility. Your customer has drawn a check, put in a crossing saying account pay only. No, it's your responsibility to obey your customer's orders. That's the first principle here. Customer is your principal. You are the agent. Now your customer has asked you, you pay 1,000 rupees to X, but account pay only to excess amount account. It can be anywhere, any bank. How do you ensure that it is going into excess bank, excess account, or someone else? When I say excess, I mean the person named X, right? Is there any mechanism that you ensure that? I don't have practically hands-on experience in this area. That's why I'm asking, especially when it comes to clearing process. How do you ensure that there's a check account pay only crossing is on there, on that? You are going to approve it or no? Shall I put it like this? You don't have a mechanism to check, but you rely on collecting bankers' prudence. Collecting bank has collected it correctly. That is why it has come to you. Based on that, you pay that. Is that okay? Is that correct? I mean, uh, I'm not asking whether it's correct in law. Is that how you pay it? Any idea? I need to get your idea and go on. I think you also reasonably have a question here. Problematic area, yes. You are depending on totally the prudence of collecting bank, right? Uh, in other words, this crossing, I don't think that it can really be a crossing in the ordinary sense because you are giving instructions to paying bank. This crossing, account pay only should not have the effect of a proper crossing even because it is something that cannot be looked after by the paying bank. How can it looked after that the collecting bank is doing what it is expected to do? I think it's a problematic area. Now, do you think that base of exchange ordinance contains any reference to account pay only crossing? You saw that in section 76, base of exchange ordinance dealt with general crossings and special crossings. But does it make any reference to account pay on crossings? No. Base of exchange ordinance does not make any reference to account pay only crossing. But if you look at the statutory laws of the UK, now later on they have recognized account pay on account what is it? Account pay only crossing has been recognized in British statutory law, whereas in Sri Lanka it is only in the banking practice but not in the statutory law. It's as good as any other endorsement, I mean, as far as the practice is concerned. You see that what I wanted to draw your attention is that this is theoretically, it cannot be a proper crossing in Sri Lanka, meaning that it is not an instruction given to the paying bank. Right? One would argue that crossings are not meant for uh, paying bank alone, right? When you see, when someone is going to endorse a check to you, you see the crossing, not negotiable. Then you need to be careful. What I am getting is not totally free of any encumbrance, all encumbrances. Because when I get a check with the words not negotiable, what I am getting is the title of the previous person. Even if I'm a bona fide person, good faith, accepting it in good faith, I'm not going to get the full title subject to hold in due course, which I'm going to deal with later. I'm not going to get full title because of this crossing, right? So you are being little concerned, alerted about the presence of this particular crossing, which is not negotiable. If that is the case, you can be similarly alarmed of the account pay crossing as well. Someone is going to give you a check with a crossing account pay only. That person is going to tell you, okay, I am going to endorse it to you. Will you be able to collect funds for that check? You won't be, because it's you cannot take deposit that into your account, right? So it might work. I mean, this is practically very useful. Now, this kind of a check would not be endorsed. That purpose is served by this, but only thing is that our law is silent on account pay only crosses, right? Any ideas about that? These concepts, good faith and negligence, would be necessary to deal with the uh, protection of collecting bank and paying bank given in the piece of exchange ordinance, which is going to be a kind of a lengthy discussion, which would have to be dealt with, breaking that section into separate parts. So I'm not going to touch on that part today, but I would be happy to assist you in any area that we have covered today. I'll skip certain slides just to make sure that don't disturb me. Other than that, I think we have covered other things. Is there any concern, any question on these areas? Okay, you seem to have no questions on that area. Anyway, I would like to take the other part next week. but you would be interested in certain other developments. Probably, since we all, most of you have, at least, unless all, have joined the banking sector after 2006. Check imaging and truncation must be the check clearing system that is known to you. But check imaging and clearing has a lot of things to do with these protection related provisions, as well as some of the things that I have discussed up to now. Now, what you see today is a totally different environment than what it used to be. The certain topics that we are discussing in this topic, so this discussion are would make the real sense in the traditional environment. But what we are living is not the traditional environment, it's the new environment after 2006 CITS operations in Sri Lanka. So I would like to connect certain points from the old classical legal regime to the present one and show how bank customer relationship and rights and obligations of parties to a negotiable instrument have been changed after the introduction of check imaging and truncation system, and also why it is in operation without even a single amendment to the bids of exchange ordinance will also be discussed, right? We can start the discussion next week, hopefully at 8:30 itself. And if you don't have any questions, I'll stop today at this point.